rise. The Court of Appeals, Division 1 is now in session.
Please be seated. Good morning. We're here in our case 1CACV 21-0070, Glacy versus Ludwig. Each side will have 20 minutes to present their argument. Appellant, you may save any amount of time for a rebuttal, but you'll have to keep track of the timing yourself, because we're going to have you argue from the bench and the clock is in the middle. Feel free to glance over or move as much as you need to. We are recording the argument, so in a day or two, the argument will show up on YouTube. Please, when you begin your argument, identify yourselves so that when we review the recording, we can keep track of who is speaking. We've read the briefs and we've reviewed the law, we've conferenced the case, so we're familiar with the facts. So when you begin your argument, just launch right in what you would like for us to know. Counsel, you may begin.
Thank you, Your Honor, and may it please the Court. My name's Aaron Martin, and along with Maricela Moffitt-Brown, I represent Linda Ludwig, the appellant. This case is about the straightforward application of procedural rules. On December 9th, 2019, the trial court entered a Rule 78C judgment in favor of mother. And 7 months later, father filed a motion for reconsideration seeking to vacate that judgment because of alleged calculation errors in the amount of arrears that he owed. And without considering the timeliness of father's motion, a threshold issue, the trial court reviewed the merits and vacated the judgment. That decision was wrong and it should be reversed. Likewise, the trial court erred when it granted father's motion and vacated its June 2020 order because father only supported his motion with representations of counsel and arguments about past agreements that were made, not actual evidence presented to the court. It was father's burden to rebut the prima facie evidence from the clearinghouse, and he did not, and that decision should be reversed. Also, because the court should reverse these two decisions, it should also reverse the award of attorney's fees that resulted from those. Father's motion for reconsideration filed in July of 2020, based on the December 2019 arrears judgment, was in its essence an argument about miscalculation of the arrears amount. There are many rules cited, many statutes cited, but all throughout the motion, it's clear the argument is that the court miscalculated the arrears amount. Now, they argue several bases for that past.
Counsel, isn't it true that the motion for reconsideration rule does not have a time limit associated with it? I'm talking about 35.1.
So Rule 35.1, you're correct, does not have a time limit to it. However, that motion for reconsideration rule does not apply to final judgments. It's very clear from the rule that to attack a final judgment, that falls under Rule 85, and for a mistake in the judgment, that falls under Rule 85B1. 85B1 is one of the enumerated rules that is governed by the strict 6-month timeline in Rule 85C.
Counsel, the December judgment, was that truly a final judgment? Did it resolve every single last issue?
Related to the arrears, it was a final judgment that resolved all the issues. Yes.
Even though inside of it, it says that it was reserving the attorney's fees issue for a later date?
As to the arrears question, the central issue, that was resolved by that judgment. And Father did not appeal the judgment. He didn't seek to have any reconsideration of that in a timely manner.
So, we're not just talking about the central issue. It needed to resolve all issues, or else the final designation was ineffective.
Well, Your Honor, we believe it was a final judgment, and that was never argued by Father, and so to the extent, he's essentially waived that.
On its face, I mean, if the court really wanted to certify that, it could have certified it under subsection B instead of C. I mean, it being that when the court certifies, saying no other matters remain outstanding, and yet the court specifically reserves a fee calculation. I have a hard time concluding that the final judgment, which is part of what we do, and we figure out things when things are appealable and when they're not.
Sure, and perhaps the calculation of the specific amount of fees may have been left open, but the award of fees was clear, and that made it a final judgment. Further, Rule 35.1.
How could a party appeal the award of fees without knowing what the amount is? I always understood that determining fees and the amount of fees was part of the judgment, that the judgment was not final until fees are determined.
And I would have to look at that more closely, to be honest, Your Honor. I think my point is, Father never challenged that this was not a final judgment. Rule 35.1, even though there's no specific timeliness requirement, motions for reconsideration have to be filed in a timely way according to the case law. And when you look at other rules related to motions for reconsideration, there's a 30-day timeline to reconsider an order. Now, this wasn't an order, it was a judgment, and even if it wasn't a final judgment, motion or Rule 35.1 does not address judgments in the plain language of the rule.
Well,
So,
if it's not a final judgment, doesn't that leave open any particular timeline for moving to reconsider?
I think there's still a reasonableness requirement that would apply in that case if Rule 35.1 applies. And the fact is, Father had all the information he needed, as he stated in the August 2019 hearing. He had the ability to produce checks, bank records, all of these things, and specifically asked for the December hearing, didn't show up at the December hearing to present any evidence, and then 7 months later decides to file for a motion for reconsideration. We think that is untimely based on the rules governing motions for reconsideration generally, which provide a 30-day timeline, and the case law stating that it's unreasonable in other situations to file even 10 weeks later. This was 7 months later, a motion for reconsideration. And Rule 35.1 has to have some element of reasonableness to it. Otherwise, you could leave a judgment or an order open indefinitely.
But
And courts
counsel,
have-
isn't that a matter of discretion for the trial court about what's a reasonable amount of time?
Well, if it is a discretionary matter, then the court can review under the abuse of discretion standard. We think
What would be the abuse of discretion then?
that Father had Essentially, what the court was saying in its ruling is that there was some injustice that happened as a result of father not being able to present evidence or go through these prior calculations. There was some error that needed to be corrected. Father,
Does your client dispute that there was an incorrect calculation? The fact that, because my understanding from the record is that the clearinghouse eventually did come to the conclusion that there had been a miscalculation. Is that not so?
the clearinghouse presented another calculation, that's correct, but that was based on going through particular orders and the clearinghouse's own interpretation of the effect of those orders. Mother was never given the opportunity to challenge those or explain what those stipulations meant, what was conceived of at the time. There had never been a full accounting before that September 2019 calculation. There had never been a full accounting of the arrears amount. And so, at best, any agreements that mother and father entered into before that would have been based on the amounts leading up to a particular hearing. And when you look at those stipulations, there are no clear dates of when the arrearages go back to, how long these will be in place. All of those things were things that mother could rebut if she was given an opportunity, and she wasn't.
She can rebut a statement and a stipulation that says as of 2013 there were no arrearages? A stipulation.
She can explain to the court what happened at that time, and that's been allowed under other cases where because there's a finding of clear and compelling evidence that's required in those situations to waive an arrearages amount, that needs to be a specific finding based on an evidentiary hearing, which she was never...
Hold on, counsel. I'm sorry to interrupt, but this is kind of confusing me. It sounds kind of like you're saying that your client could revisit a prior judgment accepting a stipulation back in 2013. Is that what you're arguing?
No, what we're arguing, Your Honor, is the clearinghouse came up with a calculation, and it said the $214,000 there were outstanding in arrearages. That is prima facie evidence of the amount that's owing. At that point, father can contest that. He's perfectly able to contest that prima facie evidence, and he should do that by coming into an evidentiary hearing, presenting evidence, and he could certainly do that by saying, we had a stipulation in 2013, we had this, we had that. What happened here is father was given that opportunity. He didn't show up to the December hearing. He filed the motion for reconsideration, and solely based on that, right, not an evidentiary hearing, but solely based on the representations of counsel pointing back to prior agreements, the court...
Prior judgments, because that stipulation was entered as a judgment, was it not?
Correct.
Okay, so my question still stands. Doesn't that argument rely upon the notion that your client is allowed to challenge a pre-existing judgment from 2013?
Our argument is that mother was never given the opportunity to address those issues adequately. Father has the opportunity to bring up those judgments and say they should apply in such and such a way that reduce the amount of arrearages, but mother was never given the opportunity to reply to that offer of evidence or reflection on past judgments.
So, and I guess I'm having a little bit of trouble with this. Isn't that a matter of record? I mean, isn't this judgment based on this stipulation in the record?
The 2019 judgment?
Correct. No.
The 2020.
The 2013 Well, it's actually entered 2014. Okay. Isn't that a matter of record?
That is a matter of record.
And doesn't your client have charge of notice of the things that she's agreed to?
She does, Your Honor, but as in the Martin versus Martin case, that was a similar situation where mother and father both had notice and specifically represented to the officer that there was a CPI increase factor that should have increased the amount of support as the years went on. That was not included in the report, even though mother and father both had notice of this, a prior agreement and an order from the court. And yet, because father missed the filing deadline, or because mother did in that case, with the state representing her, then it was not allowed to proceed because that prior agreement was not raised in a timely way. That is what happened here. With the 2019 judgment, father had several opportunities to present evidence in August, and then he received the calculation in September. He asked for the December hearing, received the opportunity to be heard, and didn't show up, and judgment was entered. It's unreasonable then to file 7 months later and ask for an unwinding of all of this when he never presented any evidence against the judgment.
Again, assuming that the 7 months calculation runs from the December entry, right? This December 2019 judgment. That's what you're basing your 7-month calculation on, correct?
Right, the December 9th, 2019.
Okay. If that calculation runs not from December, but from the January 27th, 2020 judgment, which resolved the attorney's fees issue, is there still a problem? By my math, no.
And I forget the specific date of the January hearing because he filed in July 7th. So again, if you've done the math, without knowing the specific date, I can't comment.
But the untimeliness argument depends upon the finality, the status of the 2019 judgment as being final, correct?
Yes.
Okay. And you would agree with me that inside of that judgment, the court says, I award attorney's fees, but I want you to submit a China law affidavit, and we will address that later. You agree with me? It says that, correct?
Correct.
Okay. So, and yet the finality language, the Rule 78 language, cites Rule 78C. Would you agree with that?
Yes.
Okay. So, how then are we to regard that seemingly incongruent statement? How do we regard something as final when inside of the document itself it says not all issues are resolved?
I'm not sure I have a good answer for that, Your Honor. I'd like to reserve the balance of my time for rebuttal.
Thank you, counsel. Counsel.
Good morning, and may it please the court, I am Robert Hendrickson, joined by co-counsel Jillian Hansen. I represent the petitioner, appellee Stephen Glacy, in this matter, who I'll reference as father. And the father respectfully requests that this court affirm the trial court's December 16th, 2020 ruling, granting father's motion filed on June 30th, 2020, and his motion filed on July 7th, 2020. Father also requests an additional award of fees in addition to confirming the trial court's award of fees as well. Father's requests are essentially based on three overarching arguments, which was there was not proper notice provided to father, as the trial court admits, for the June 3rd, 2020 hearing, and that father timely filed his July 7th, 2020 motion for reconsideration and relief, which was properly supported by the record itself and the subsequent 2020 calculation. the trial court properly found that father owed no support as of December 2019 and properly vacated the December 9th, 2019 judgment.
Why did father take so long to move to reconsider?
So the timing of it, I believe, is supported by the record itself. In his motion to continue on March 16th, 2020, he outlined significant illnesses that he was facing, not only in the prior 5 weeks, but over years as well. The other concern, I believe, was in addition to notice. Whether valid or not, there's certainly, from father's perspective, had a concern in regards to notice, not only the December 2nd, 2019 hearing, but certainly as the trial court confirmed regarding the June 3rd, 2020 hearing. And when that order came to light, that is when he was actually, and I think that's a clear distinction for that June 3rd, 2020 hearing, is it was for contempt. And that highlights and emphasizes the need for notice, which in the transcript on the December 2nd, 2019 transcript for that hearing, Judge Mandel articulates that very clearly in terms of moving forward with fees and sanctions and contempt and the need for notice moving forward. So the record supports the analysis there in terms of father's reasoning from there. And as the court has highlighted in its questions today, the difficulty when he did retain counsel was procedurally how to move forward with what had just happened. It was an interesting line of events, I guess to say the least, in terms of having a trial on August 30th, 2019. The ruling comes out on September 10th, 2019, and the only finding or order, which there wasn't an order, it was a finding in terms of arrears, was ordering a calculation, which then came out on September 25th, 2019, sets a hearing on December 2nd, 2019, which seems to be evidentiary, but labels it a status conference, doesn't have any other form of notice or any terms of contempt or sanction of what may result from that hearing on page 7 of that 10-page September 10th, 2019 hearing. December 2nd, 2019 hearing occurs. They find him, they rely on the 2019 calculation, enter a judgment against him, and then proceed to reserve contempt and sanctions for a future hearing. And the court even specifically, announces that an order to appear needs to be issued. The other challenge that I find difficult with, I guess, a future contempt hearing, which was eventually held on June 2nd, 2020, was under Rule 92, the court needed to make an express finding that he had notice of not only an order to appear, but also a petition, and a petition was never filed. I guess unless the court is relying on Mother's 2018 petition to enforce him for contempt. But again, in June 2nd, 2020, regardless, the court never made that express finding of notice of not only a petition, but an order to appear or some type of notice. And admittedly, the trial court looked at the record and saw that there was no notice whatsoever for that June hearing. And that was also part of the 3-month gap of why the timeliness of father's June 30th and July 7th, 2020 motions.
So let's talk about whether your Rule 85 motion is timely. Why wasn't the December 2019 order, which included Rule 78C language expressly, wasn't that a final appealable judgment?
So, and that was the difficulty we were facing. I think the argument and the analysis is there that it could be. But under 78C specifically, it addresses attorney's fees. And if all issues aren't resolved, it may not be an appealable order, which was the challenge that we were facing when an order then came out in January, at the end of January 2020. Another order came out in June of 2020. And from father's perspective, it was to allow the opportunity for the trial court, based simply on what was a very clear record, to fix what happened before seeking any other alternatives, including an appeal.
Did the parties litigate whether it was a final appealable order? Because if it was, obviously,
No, I'm not.
your client should have appealed within 30 days.
Correct, and from my review of the record, no, that issue was never litigated or argued in terms of it being a final appealable order. The other perspective that I think is important to emphasize in terms of what was brought up is Mother's ability to challenge the 2020 calculation. To highlight in the August 20th, 2020 transcript, the party specifically waived the right to an evidentiary hearing. And so that was an interesting procedural aspect of it as well, in terms of challenging the 2020 calculation that actually came out before that hearing. And then the court subsequently allowed mother to file her responses to father's June 30th and July 7th, 2020 motions. In terms of, just briefly, in terms of the June 30th, 2020 motion, I believe that it's clear, and the trial court confirmed, that there was a lack of notice there, and that it should confirm, this court should confirm the fact that the judgment and really the order of contempt was properly vacated afterwards. The other highlight that I want to make as part of the clarity there is, it seems like in the transcript, the court entered another judgment, at least it says so in the transcript, but in the subsequent minute entry, it never did. The only order in the subsequent minute entry was a finding of contempt, and actually sent father to the ACE workshop and enforcement court and further sanctions, which, to me, the reason I raised that is further highlights the need for notice when we're pursuing contempt under Rule 92. There had to have been an express finding of notice. There was not, and in fact, after later on in the December 2020 ruling, the court noted that there was no notice, although it thought that it did. And moving forward to the, probably what would be described as the larger issue in terms of the timeliness of father's motion for reconsideration dated July 7th, 2020, it appears that mother's argument relies heavily on the concept from Martin v. Martin that if father can apply in one subsection under Rule 85, he's boxed in, and there's no other avenue for him to move forward. And we would argue there is no support for that claim, even from Martin itself, which analyzed multiple subsections of Rule 85. And in addition, as the court has noted, father filed under several avenues of moving forward because of the procedural nature of the matter up into July 2020, including Rule 35.1. which 35.1 specifically in the 2019 rule amendments eliminated any type of deadline. Previously under Rule 84, there was a 30-day deadline. This was specifically eliminated. And in terms of still needing to be timely or still reasonably timely filed under case law as well as Rule 82, this court can presume that the trial court made those findings, that it was reasonably and timely filed at the time, and the fact that it moved forward and granted. There was no request for findings of fact and conclusion of law, and this court can presume that it made the appropriate timeliness findings in conjunction with the July 7, 2020 motion. The other difficulty, well, I shouldn't say difficulty, or the part of the analysis of the December 2020 minute entry is the trial court doesn't specify exactly what it is that it filed under. But repeatedly, the trial court references it as a motion for reconsideration repeatedly. So that may provide more evidence as well to rebut mother's argument that the trial court didn't rule under 35.1. The other argument that was proffered in regards to 35.1 is that 35.1 addresses ruling and orders, whereas 85 addresses judgments. Counsel admittedly had difficult finding case law clarifying the difference between the three, and relying on Black's definition of the three, I think it becomes clear that a ruling is encompassing of both, and that there is a distinction between orders and judgments, but judgments are orders, but orders are not necessarily judgments. So for 35.1 to talk about orders and rulings, at least under the definitions of those, it encompasses judgments as well.
Counsel, the final arrearage issue, that stems originally from a petition filed by mother, correct? She's the one who raises an arrearage issue to begin with, correct?
Yes, in terms of, if we're going to specify the pleadings that were standing, is father filed the petition to modify legal decision, parenting time, and child support. And whenever a child support, the ongoing modification is ruled on, the court inherently must look at arrears in terms of setting payments. But mother was the only one to file a petition to enforce in contempt on the specific issue.
Specifically related to arrears?
Correct.
Okay. And so after, there's a big hearing that happens in September. Your client is present for that hearing, correct?
If Your Honor is referencing the August 30th, 2019 trial on all the petitions?
Correct.
Yes.
Okay, the kind of omnibus hearing.
Yes, the
Okay,
trial.
So, and then the court makes a series of rulings and then says we're going to address arrearages later.
I don't know if I necessarily agree with the arrears, that we're going to address it later. I guess procedurally that's how it happened. I don't know if the trial court specifically said that. The only finding or document that I can see in the minute entries, it said it's going to order an arrears calculation. There seems to be a dispute based on the testimony of the parties. Let's come back on December 2nd, 2019. And so I apologize if I misunderstood the question, but I found it interesting in terms of everything that went on in that hearing. There was only a sentence or two in regards to the arrears and basically just reordering the calculation and then setting what the trial court labeled as a status conference.
Okay, so, and is that the dispute about, or the concern about notice that you were talking about earlier?
So there's the two here.
Specific to the December hearing.
So the concern that I had with the notice is specific to the December 2nd, 2019 hearing, was the fact that the court appeared to be setting an evidentiary hearing and labeled it a status conference and put it in page 7 of a 10-page minute entry, and then proceeded to enter a judgment in what looked like a default situation because of father's failure to appear. And even under Rule 44, there should be a 3-day notice or some kind of language that if you do not appear to this hearing, you will be defaulted. And in fact, the trial court talked about at length in the December 2nd, 2019 hearing of how important it was that a specific order to appear now needed to be issued, now needed to be served in order to issue sanctions and contempt against father, even though it proceeded and entered a judgment against him in default at that December 2019 hearing. So I have concerns in regards to notice in that retrospect of a default situation and possibly contempt, and what seemed to be an evidentiary hearing but was labeled at a status conference, which if both parties appeared, there should not be evidence, and the court is bound not to be able to make orders unless agreed upon by the parties.
Okay. Counsel, are you familiar with the Yee case this court recently published, Yee versus Yee?
I am not.
It's 251 Arizona 71.
I am not.
You're not. Okay. That was just asking.
Sure. Moving forward, and putting aside the 35.1 argument in terms of timeliness, in addition to there was other rules of procedure that were cited to in Father's July 7th, 2020 motion, including 85B 4 through 6, which also deserves analysis in Father's opinion as well. Specifically, starting with 85B 4, it seems clear that the Martin case says that there's a difference between void judgments and are voidable. And a judgment needs to be void, it cannot be voidable in order to qualify under B4, and outlines what appears to be 3 prongs: that the court lacked jurisdiction over the subject matter, lacked jurisdiction over the persons involved, or lacked jurisdiction to, quote, render the particular judgment or order entered. And while there's no dispute that the court had jurisdiction over the subject matter and the persons, I believe that the 3rd prong is worthy of an analysis because for 3 reasons to analyze that 3rd prong of 85B4. And one of them is the sole basis for the December 2019 judgment was a calculation that the trial court later found incorrect and issued a new one. And therefore, there is no longer any basis to enter a judgment at all, which to me would cut off the jurisdiction in order to render the judgment or order that it entered. Additionally, going back to the default hearing that I argued before, for the court to enter default against father, there was no notice of not a minute entry or any type of order to appear with default language in order to move forward with him, to default him in that manner. And finally, the 3rd reason is that it exceeded mother's original petition probably by 4-fold at least. And under case law and Civil Rule 54D and Family Law Rule 44.1A, a judgment would be null and void, at least to the extent that it exceeded what the petition outlined. So for those 3 reasons, I believe that 85B4 and specifically the 3rd prong under Martin would be worthy of analysis to provide yet another avenue for a father to move forward in his July 7th, 2020 motion. The other subsection was 85B5 that father argued as well, which outlines several different options under B5, including satisfaction of the judgment itself. And I think that the record is clear, and the 2020 calculation is clear, that shows father owed no arrears as of December 2019. And there's no timeline for 85B5, the 6-month rule anyways, and the record is supportive of the fact that he owes no arrears and that the judgment was satisfied. Mother argues that satisfaction, at least from my perspective or review of the briefing, that satisfaction can only be done by actual proof of payment, and I don't believe that there's legal support regarding that argument. And briefly, there's a second part of 85B5 that talks about it would be inequitable to apply the judgment prospectively. In Father's July 7th, 2020 motion, he outlined 3 equitable arguments under waiver, equitable estoppel, and laches that could also provide him an avenue to move forward, even presuming that there is a timeliness concern under the other subsections of Rule 85. And finally, under 85B6, now Martin seems to make clear as well, and as well as other case law, that the avenue of 85B6 is cut off if there's other subsections that would apply. But to me, in this particular situation, if there's distinct arguments or claims that don't fit under the other subsection and would only fit under B6, that may provide an avenue for father as well. And the claim would be that the 2019 judgment invaded, and maybe even could be argued modified or set aside, prior stipulations that were confirmed as orders, which doesn't seem to fit under 85B1 through 5. The only way to make that argument would be under B6. And because that is a separate, distinct claim that wouldn't fall under any of the other 5 subsections, I think that may be worthy of an analysis as well. And finally, if the court goes down the path of a mistake, I think 85A is worth looking at as well, which actually has language that the court can do this on its own, and that the court can do it by overturn or correct a mistake by motion, and there's no deadline associated with 85A either. Mother raises the argument of the difference between clerical errors and judgmental errors, and clerical error to me is appropriate for this matter because the transcripts, and 2 of the transcripts at least, make clear that the trial court intent was to get the arrears calculation right, and the December 2019 judgment does not do that. And so to allow for to go back and correct the omission or oversight or mistake.
Counsel, but isn't it true that, I mean, there really isn't like a situation here where the court just put the wrong number in? Like there's no added zeros, there's no, I mean, with regard to the December matter, the court intended to enter a number, and that number was the correct number under the court's understanding of the situation then. Isn't that true?
I think that the court intended was to enter the correct number, which could have been 0, just as easily as it could have been $1 or 100,000. It was trying to get it right.
But isn't that a fundamental issue of rightness and wrongness versus, oops, this is a syntax error or a mathematical computational error?
Yes.
Isn't there a difference between those?
Yes, and I would argue, and that's why I request that it's worthy of analysis, not necessarily, it may not be a prevailing one, but I think it's worthy of looking at because of the issue that we're dealing with in terms of mistakes, omissions, and oversights. And it's difficult to show, because I would agree with the analysis that we're not talking about a mathematical error here. The trial court missed prior confirmed orders, and so did the clearinghouse, until it was brought to the attention and was allowed to go back and review that. So yes, that would be the counter argument to the argument under 85A. And what I would proffer as far as the analysis is that the intent was to get it right. And because of the omission, and which is included under 85A or oversight, that the court made that clerical error by not simply looking at the record. And in the limited time I have, the third overarching argument was for the father to receive an additional award of fees, because what mother essentially seems to be arguing is attempting to receive a windfall under a hyper-technicality of timeliness.
Thank you, Counsel. Your time is up. Rebuttal, you may proceed.
Thank you, Your Honor. Regarding the arguments related to Rule 85B4 through 6, I think I'll just refer you to our reply beginning on page 13. I think we've addressed counsel's arguments there. Relating to the timeliness of Rule 35B1, there's a significant interest in the judicial system as a whole of protecting the finality of judgments and making sure that parties seek relief in a timely manner in a way that doesn't prejudice those who already have a judgment in place. And beginning in the answering brief, pages 14 through 17, counsel talks about the various stipulations that we discussed earlier that were put into the form of a court order. Under the appellee's own reasoning, mother could today file a Rule 35.1 motion and seek reconsideration of those prior orders because there's no timeliness requirement.
But that would have to be granted by the court, correct?
It could, but mother raised the timeliness issue in response to father's motion in June 2020, and the issue was never addressed.
But my point is that it would be within the discretion of the court whether or not to take that up. Is that?
It would be, and the court might find that it's unreasonable, not timely, et cetera, just as this court can find that a 7-month delay after admitting in court in August 2019 that you have all the evidence at hand, you ask for a specific hearing in December 2019, that the court says in its order, father requested the opportunity to provide evidence to refute the arrearage calculation. So it ordered a status conference to address the issue of any arrearage and potential payment on the arrears for December 2nd, 2019.
Counsel, are you familiar with the Yee case?
I'm not, Your Honor.
Okay.
Apologize.
I just wanted to know.
Mm-hmm. So after stating to the court that he has the evidence he needs to rebut the presumption from the clearinghouse numbers, specifically asking for a hearing, having that hearing granted, having the opportunity to present evidence, he didn't show up. And so we think it's unreasonable, even under 35.1, that it's unreasonable to file 7 months later to attack a judgment that was entered. Any negative result is a result of father's own delay in presenting that evidence. Thank you.
Thank you, counsel, for your arguments today. We'll take this matter under advisement and we'll issue a decision in due course. We're going to set recess while new counsel comes forward for the next case. Thank you very much.
Thank you.